So on to the topic of real estate mortgage. Okay, so under the civil code, this topic is just labeled mortgage. Okay, so if you look at the civil code, yung section doon na mortgage, ito yung real estate mortgage. Okay, so let us define real estate mortgage, or also called mortgage, plain mortgage, or real mortgage. Okay, is a contract whereby the debtor secures to the creditor the fulfillment of a principal obligation, especially subjecting to such security immovable property or real rights over immovable property. And the case of principal obligation is not complied with, the time stipulated. So the parties to real estate mortgage is the mortgagor and the mortgagee. So the mortgagor is the debtor, obligor, or passive subject. Why? Because he has the obligation to provide the property subject of the contract of mortgage. Okay, while the mortgagee is the active subject because he has the right to demand from the mortgager to provide the security for the obligation, the principal obligation. Okay, so that is why the mortgagee is the creditor or the obligee, and also the active subject. So the subject matter, take note, for real estate mortgage are immovables or real property, okay, like land and anything attached to the land, including buildings, okay, as well as rights, alienable rights over immovable property. Maybe you are a co-owner or you are a co-heir, okay, you have a claim over the property, and that claim is a right, alienable right. Ibig sabihin, uh, you can either sell that also, you can also make it a subject of real estate mortgage, okay. Basta the right must be over it, immovable property, not a right over personal property. Okay. So immovables and rights over immovable properties. Of course, the efficient cost is the same as pledge, the security of the principal obligation. So this is important for real estate mortgage. It is indispensable in order that the real estate mortgage may be validly constituted, that the document in which it appears must be recorded in the registry of property. Okay, sa register of deeds yan. So indispensable siya. Ibig sabihin, this is required. What if you constitute a real estate mortgage over a real property and you did not uh, have it recorded in the register of property? The consequence is that the mortgage is only valid insofar as the parties are concerned. It will not be bind. It will not be valid insofar as other persons or third persons are concerned. Okay. So if the instrument is not recorded, the mortgage is nevertheless binding between the parties. Okay. So this is real estate mortgage. Number one, the contract must be in a public instrument class, kasi real property. Public instrument, ibig sabihin naka-notaryo. And then, dapat naka-record sa register of property. Pag hindi naka-record sa register of property, okay, so it will only bind the parties. Tapos yung instrument, kunwari, hindi siya public instrument, then it will be void because the law says the instrument must be a public instrument. Basta anything transaction pertaining to land, immovables, it must be in a public instrument. Okay. Characteristic, the real estate mortgage is a real contract, even if there is no such thing as delivery of the thing. Why? Because you cannot physically put the land into your hand and transfer it to the hands of the mortgagee. That is impossible. So if while the real estate mortgage there is no physical delivery, there is still some form of a constructive delivery. If you can still remember your tradition symbolic tradisyo longamano, tradisyo, and so on and so forth. Constitutum possessorum. Nasa ilalim nun nakasulat, execution of the deed is like delivery also. Okay. So, for the mortgage, real estate mortgage to be account to be perfected, the deed of the mortgage must be executed, okay, in a public instrument. Because without such execution of the deed, then there will be no mortgage to talk about. Okay. So real estate mortgage is a real contract that is perfected by the execution of the deed of mortgage and not on the meeting of the minds. Number two, it is also an accessory contract just like pledge because it is dependent upon a principal contract. Then it is subsidiary. There is this principal contract, and unless and until the principal contract is violated, saka pa lang siya mag-come in na contract. That is why it's subsidiary. It's accessory and subsidiary. Then it is a unilateral contract because only one of the parties has the obligation. That is the creditor who is obliged to free the property from the encumbrance upon the fulfillment of the principal obligation. Number 5, the mortgagor, as a general rule, retains possession of the property mortgage. O remember class, sa pledge, yung personal property kailangan i-deliver. While sa real estate mortgage, of course, because it is impossible to deliver the land or the immovables, kaya nga immovable, okay, the possession will still remain with the mortgagor who is also the debtor. Number 6, the objects of the real estate mortgage are immovables and inalienable rights imposed upon immovables. Na-discuss na yun kanina. Essential elements 1, 2, 3 are the essential elements found under the common provisions applicable to both mortgage and pledge. Okay, that the mortgage must be used to secure the fulfillment of a principal obligation. The mortgagor must be the absolute owner of the thing, and he has the predisposal of that property. If he is or if he is not the owner, he must be if he has no predisposal, he must be legally authorized for the purpose. Then number 4, for real estate mortgage, it must appear in a public document duly registered with the registry of property. So kinds of mortgage, okay, you have voluntary, this is or also called conventional. This is agreed upon by the parties. And for the purposes of this discussion, we will be discussing voluntary mortgage. Okay. There are also legal mortgages found in Article 2125, 2082, 2083. But for purposes of this course, we will not tackle about that anymore. And then we also have equitable mortgage, which we have discussed in sales. Okay, you can still remember your sales with a right to repurchase or pacto diretto sale. If the parties do not and if the intention of the party is not clear, then it shall be considered as an equitable mortgage. Ito yun, part number 3. Okay? Though it lacks the proper formalities of a mortgage, but the intention of the parties was to make the property as a security for a debt. So those are the 3 kinds of mortgages. So the effects of real estate mortgage. So once the real estate mortgage is constituted, it creates a real right for the mortgagee or the creditor, because he already has a claim, some form of a lien inseparable from the property. Okay. A lien is a claim over a property, and when dahil it is in a public instrument and duly registered with the Register of Property, then the lien becomes inseparable from the property. But you must remember, class, the real property remains to be the ownership of the mortgagor debtor. Okay? Only that the creditor mortgagee has a lien. Okay, may claim siya. It is a real right enforceable against the whole world. So that, okay, because the debtor mortgagor remains to be the owner, and as an owner, pwede niya ibenta. Okay? Pwede niya ibenta yung property because sabi ng batas, okay, it is void for the parties to agree that the owner cannot anymore alienate the property that is void, because the property remains to be under the ownership of the mortgagor debtor. Only that the creditor mortgagee has a right over that, and that right is a real right. So that when the property involved is sold to another person, that third person must recognize the real right, the lien over the property or the mortgage. In that case, class, the buyer of the property becomes the new mortgagor. Okay, because in the case na hindi magbayad yung original owner or debtor, mortgagor, okay, the property, even if it is already in the hands of a third person, may still be uh, taken by the mortgagor, mortgagee creditor, so that it can be sold at public auction pambayad sa utang ng original owner or debtor. Okay? So the real proper estate mortgage directly and immediately subjects the property upon which it is imposed, whoever the possessor may be. Take note, whoever the possessor may be, okay, he is subject to the fulfillment of the law for those security it was constituted. So yung claim under sa real estate mortgage, magsunod-sunod siya doon sa property. Kahit sino pa ang nakahawak ng property, kahit sino pa may-ari ng property, new owner ng property, he is bound to respect the real estate mortgage. Why? Because it is in a public document and duly registered in the registry of property. So, bound ang third persons. The problem is if hindi nakaregister sa registry of property, okay, the third person, especially if he has no knowledge, may not be bound to respect the real estate mortgage. Because the law says, if it is not recorded in the registry of property, okay, only the parties, the mortgagor and the mortgagee, is bound to the real estate mortgage. Okay, so if it becomes the property of another person who has no knowledge because it was not recorded, okay, what the creditor can do is to go after not the property, because the third person is not bound. What the creditor can do is go after the debtor for the amount of the debt and some form of damages for the violation of the contract. Number 2, the real estate mortgage merely creates an encumbrance. Okay, an encumbrance class is alien, ay claim na nakapatong doon sa property. Okay, it does not invest ownership on the mortgagee creditor. May claim lang siya, may encumbrance lang siya. May encumbrance lang na nakapatong doon sa property, but it is not ownership because there is no transfer of ownership in real estate mortgage. Okay, the law considers void, as discussed kanina, any stipulation forbidding the owner from alienating the mortgage movable because the owner is still the mortgagor is still the owner, remains to be the owner. Okay, may encumbrance lang yung property, may nakapatong na claim. Okay, but remember that under the revised penal code, if the owner of the property na naka-mortgage, kahit naka-mortgage na, pwede niya ibenta. But he must tell the buyer na this property is under a real estate mortgage para alam ng buyer. If he does not inform the buyer of the encumbrance, he may be liable for estafa. Okay? So any person who, knowing that the property is encumbered, meaning my real estate mortgage, shall dispose of the same as unencumbered. Okay, so magiging liable siya for estafa si seller. Si owner seller. Extent of the mortgage. So unless otherwise stipulated, the general rule is that the mortgage constituted on immovable property is not limited to the property itself. Okay, if it is land, it also includes, kahit na walang sinabi, all accessions, improvements, growing fruits, and rents or income. Okay, as well as the proceeds of insurance should the property be destroyed, or the expropriation value of the property should it be expropriated. So pag nagprenda ka ng lupa, paglupa, okay, consider niyo na kasama yung mga tanim doon, mga fruits, Kung may property na may building, kasama yon. Pati yung rent doon sa building, kasama yun sa mortgage. Okay? And then, if the insure yung building, tapos nasunog, pati yung proceeds ng insurance, kasama yun sa real estate mortgage. Okay? Pati yung expropriation property. Ang expropriation class, ibig sabihin, property was taken by the government because it will be used for public purpose, tapos babayaran lang yung may-ari ng just compensation. Pati yung just compensation, kasama rin yung sa mortgage. Take note, itong mga amounts na ito, okay, this does not become the property of the mortgagee. This still remains to be the property of the mortgagor, only that it will be held as a security for the principal obligation. Si mortgagee ba, pwede niya ibenta yung right niya sa mortgage? Okay, ikaw ang mortgagor, ako ang mortgagee. Yung bahay mo, ni-mortgage mo sa akin. So, ako yung creditor. Okay, pwede ko ba ibenta yung right ko sa mortgage to another? Para yung another person naman ang magiging new mortgagee? The law says, the answer is yes. The real estate mortgage may be alienated or assigned by the mortgagee to a third person in whole or in part with the formalities required by law. Okay? Pwede yun. Extinguishment. Okay? By the fulfillment of the principal obligation, of course, pag mabayaran yung utang, tapos na yung mortgage. By renunciation or abandonment, of course, if the mortgagee says, ayoko na nung prenda, pero the utang still subsists, pwede pa rin yun. Okay? So, waiver by the creditor. Okay? Halimbawa, sabi ng creditor, I will not anymore go after the mortgage. Okay? The mortgagee may waive the right to foreclose his mortgage and maintain a personal action for the recovery of the indebtedness. Okay? So, if the creditor mortgagee waives the real estate mortgage, mag-i-extinguish na yung mortgage. Pero hindi ibig sabihin, extinguish na rin yung principal na utang. He can still maintain an action or he can still file an action sa court para ma-recover yung or para ma-fulfill yung principal obligation for the recovery of that indebtedness. Okay. Number 2, the mortgagee cannot have both remedies. He has only one cause of action, so he can only choose between i-foreclose yung property or mag-file ng complaint para mabayaran yung utang. So, dalawa lang. Pili siya sa dalawa. Once na-waive niya ng foreclosure, doon na lang siya sa specific performance of the payment of the debt. You cannot have both. Foreclosure. Okay, we have been mentioning foreclosure. Foreclosure pertains to kung sa pledge pa, if hindi nagbayad yung pledge or kukunin ng pledge yung property para i-public auction. Okay, ang tawag doon sa pledge is sale at public auction. But for purposes of the real estate mortgage, the term used is foreclosure. Okay, so sa foreclosure, this is available to the mortgagee, which subjects the mortgage to the satisfaction of the obligation to secure the mortgage to the sale of property at public auction. Public auction pa rin siya. And then the process thereof shall be for the payment of the claim. Pero ang term ng ginagamit sa mortgage is foreclosure. Sa pledge is public sale or public auction. Okay, kahit basahin mo ang batas ng pledge, walang nakasulat ng foreclosure. So, when you say foreclosure, hindi na nakabayad yung mortgage or debtor. That is why the creditor mortgagee is now taking the property so that it can be sold at the public auction, and the proceeds will be applied for the payment of the principal obligation. So, there are two kinds of foreclosure class, judicial foreclosure and extrajudicial foreclosure. So, from the term judicial foreclosure, file ka sa court para i-foreclose yung property. Extrajudicial foreclosure, if you have agreed, if the original parties agreed na wag na mag-file sa court, extrajudicial na lang, sila na lang magbenta, pwede rin yun. Okay? So if there is no agreement, you go to court and file your foreclosure. So judicial foreclosure muna. Let us discuss the foreclosure that is filed with the courts. Okay. This is a foreclosure by bringing an action for the purpose of foreclosure in the regional trial court. Saan na regional trial court? Sa place where the property is located. Okay. The procedure here is governed by Rule 68 of the Rules of Court. Okay, ang Rules of Court class, ito yung sinusunod ng mga korte sa paghearing ng kaso. So, Rule 68, nandun ang judicial foreclosure. So, if there is a balance due to the mortgagee, after applying the proceeds of the sale, the mortgagee is entitled to recover the deficiency, except when the mortgagor is a third person, in which case the creditor should recover the deficiency from the debtor himself. This must be embodied in the judgment of the court as a deficiency judgment. Ibig sabihin, binenta yung property, kulang pa rin, pambayad. So, dahil sa court ito, the court will make a judgment na ang kulang, babayaran pa rin ng debtor. Okay? Pero if the mortgagor is a third person, ibig sabihin ibang, kasi pwede pa rin sa real estate mortgage class, ikaw ang nag-utang ka sa akin, pero ang lupa na i-mortgage is sa nanay mo. Okay? Then later on, di-foreclose ko, kulang pa rin yung proceeds, hindi ko sisigilin ng mama mo, kundi ikaw. So, when the mortgagor is a third person, the creditor should recover the deficiency from the debtor. Okay? So, dapat nakasulat ito sa judgment ni judge sa court, kasi court ito, judicial foreclosure, na yung kulang, bayaran ni debtor. So, tapos na, public auction na. Si judge, inutusan niya si sheriff, i-public auction mo yan. Okay, tapos nabenta na ang real property. So, ang proceeds will be, number 1, ibayaran mo na yung cost ng sale. Yung sale ng sheriff, yung nagastos ng sheriff sa pagbenta ng property. So, bayaran mo yan. Number 2 is the amount due to the mortgagee. Number 3, if meron pang ibang mortgagee, bayaran din sila. Then, ang sobra, ibalik sa mortgagor. Okay, so ibalik ang sobra sa may-ari or sa mortgagor. Extrajudicial foreclosure naman, this is outside of the court. Extrajudicial. So, this is agreement by the parties. So, the parties will agree na wag na lang mag-file sa court. So, original na nila, sa original na mortgage, okay, nandun yung property, nandun yung utang, and then may stipulation doon, may agreement, na in case of failure to pay, extrajudicial foreclosure na lang, hindi na mag-judicial foreclosure. Ito yon. So, pag hindi nakabayad, if stipulated by the parties, a mortgage may be foreclosed extrajudicially by the mortgagee by an extrajudicial sale of the mortgage. This is governed by Act number 3135. So, yung judicial foreclosure is governed by Rule 68 of the Rules of Court. Ito namang extrajudicial foreclosure is governed by Act number 3135. This is another law. So, just an overview of Act 3135, ang procedure na kasulat doon. Number 1, public auction pa rin. Saan gagawin? In the province where the property is situated. Kung saan nandun ang property. So, mag-post ng notice of sale at least 3 public places to inform the public. And then, i-publish a newspaper of general circulation. And then, notice to the mortgagor is not mentioned in the law. So, it seems it is not required. Okay. Then, the mortgagee, after the sale, is entitled to recover the deficiency. Ibig sabihin, if nabenta niya yung property, kulang pa rin, the mortgagee can still collect from the debtor kasi kulang yung property na giprenda niya. Kulang pambayad yung proceeds. Pwede pa rin siya collectahin sa balance. Okay, the balance, if any, kung sobra naman, shall be paid to the mortgagor. This is my opinion because yung nakasulat sa books, yung nakasulat sa law, wala. Silent siya. So, because this is real estate mortgage, sa judicial foreclosure, ibalik yung sobra pag sobra yung proceeds. So, it is my opinion that also in extrajudicial foreclosure, the balance should be return to the mortgagor or to the owner. Because this is really the nature of mortgage. Pag kulang, pwede bayaran, pwede kolektahin, pag sobra, ibalik. So, yun ang fair. That is the fair na interpretation of the law. Take note class, ang sa pledge naman, pag may kulang, hindi na makolekta. Pag may sobra, hindi rin ibigay. Unless may agreement na ibalik. Redemption. Take note class, this is not the same redemption doon sa legal redemption. Sa pacto de retro sale, this is not the same as redemption by co-owners and owners of adjoining lands. Iba yun sa sale yun. Sa topic yun ng sale. Okay? Para ma-refresh lang yung redemption doon, legal redemption doon sa sale. Kapag ka may pacto de retro sale or sale with the right to repurchase, tapos i-repurchase na ng original na seller, yun ang legal redemption doon. Sa conventional redemption pala. Sa legal redemption naman, if yung co-owners nagbenta, pwede i-redeem ng isang co-owner yung adjoining lands, okay, binenta yung isang lupa, pwede i-redeem ng katabing lupa, whether sa rural or sa urban lands. Okay? Iba yun, sa sale yun. This is redemption. The redemption mentioned here is yung naprenda mo, na foreclose, na benta sa public auction, pwede mo pa ba mabawi? Yun ang redemption na ginamin dito. Okay? So, this is real property na naprenda. Hindi na foreclose. And it was sold to public auction. Pwede pa ba i-redeem nung may-ari? Sayang kasi yung lupa. So, there are two kinds of redemption, equity of redemption and the right of redemption. Okay? So, when we say equity of redemption sa real estate mortgage, take note, real property to class. Okay? It is called equity of redemption. This is the right of the mortgagor to redeem the property. Take note, after his default but before the sale. The mortgage is confirmed by the court. Okay? So, equity of redemption, kung ibig sabihin, judicial foreclosure ito kasi may court na ka-involved. Judicial foreclosure, hindi nakabayad. So, di-foreclose. Nag-file ng case sa court under Rule 68 of the Rules of Court. Okay? So, habang na-hearing yun, pwede yun i-redeem. Sabi ng mortgagee, huwag ka na lang mag-file ng, hindi na natin ituloy case, bayaran ko na lang lahat para mabawi kayong lupa. Pwede yun. That is called equity of redemption. But the mortgagor has only up to the time before the sale is confirmed by the court. Okay? So, kahit may sale na, may public auction na, pero wala pa na-confirm ng court kasi dapat may order sa court na i-approve niya ang sale. So, during that period, basta wala pa na-confirm ng court, pwede pa i-redeem. That is called equity of redemption. Ano naman ang right of redemption? Right of redemption is the right of the mortgagor to redeem the property within a certain period after it was sold for satisfaction of the mortgage debt. Nabenta na, na-approve na ng court. Pwede pa babawiin? Yes. In judicial foreclosure. Okay. The general rule is that the mortgagor cannot exercise the right of redemption after the sale is confirmed by the court. Hence, the mortgagor cannot redeem before the court confirms the sale. Can redeem. Okay. However, if the property has been mortgaged in favor of banks, banking credit institution, redemption is allowed within 1 year from the registration of the sale. So, take note class, as judicial foreclosure, once na-confirm na ng court ang sale, wala nang right of redemption. Okay? Kasi final na yung decision ni judge. Before sa decision ni judge, before sa final redemption, or sa final approval ng court, pwede pa i-redeem under equity of redemption. Pero pag na-approve na ng court, tapos na, naputol na yung ownership ni mortgagee, nalipat na doon sa buyer ng lupa. So generally, kapag judicial foreclosure, Once the sale has been approved by the court, there is no more right of redemption. Wala na ring equity of redemption doon kasi tapos na ang period. Pero may according to law, there is another law that if the property is mortgaged sa banking institution and credit institution, redemption is allowed within 1 year from the registration of the sale. Ibig sabihin ng registration of the sale kasi pag nabenta yan, i-register yan sa Register of Deeds. Okay? So, from the time na na-register doon sa Register of Deeds, hindi sa time of the sale class ha, but the registration of the sale. Within 1 year, dapat i-redeem. Pwede pa ma-redeem. Sa extrajudicial foreclosure naman, the mortgagor may redeem the property within 1 year from the date of the registration of the sale pa rin. So itong 1 year, applicable lang sa banking institution, credit institution, at saka extrajudicial foreclosure. Okay, right of redemption yun. Yung equity of redemption naman sa judicial foreclosure yun, before the court will approve the sale. Please take note of that. That is very important. So how is redemption made? Number 1, the redemption must be made within the period allowed by law, of course. Number 2, siyempre, bayaran mo yung purchase price of the property plus 1% per month together with the taxes paid by the buyer. Okay. Computed from the date of registration of the sale. And number 3, a written notice of redemption must be served on the officer who made the sale and duplicate file with the proper register of deeds. So ganyan mag-redeem. So that is all for real estate mortgage.